My most viewed YouTube video here is about how Ontario is facing one of the biggest land claim stories in modern Canadian history, and almost nobody really understands what's happening, including myself. I tried my best to research it, but today you're going to hear the clearest explanation that you'll find anywhere straight from the source. So when I put out this video, it's the most comments I've ever received on a video on YouTube, and I had hundreds of people saying the exact same thing, which was, you need to talk to this guy, Bruce Pardy from Rights Probe. So I did exactly that. And trust me, you're going to want to watch the entire video. I know my interview YouTube videos are often on the longer side, but I promise it'll be worth the while. I learned a ton from this conversation. It went to a lot of places I didn't expect, and it completely changed the way that I think about land and government and property rights in Canada. Here's everything we break down in the episode. What the Ontario and BC land claims actually are without any political spin. Why this could become one of the biggest real estate stories of the decade. How treaty lands work, who owns what, and why there's so much confusion. Whether or not renters, homeowners, and municipal governments should actually be worried about this stuff. What governments are doing and not doing behind the scenes here. And how this connects, if at all, to zoning, housing supply, development, etc., and property taxes and land transfer tax. And what happens next, the range of potential outcomes and the scenarios that almost no one is prepared for. This is, from my perspective, one of the most important conversations that I've ever filmed on this channel. So without wasting any more time, let's get into it.
Thank you, Daniel, for having me on. Yeah, as you say, I'm a prof at the law school at Queen's University. I'm the executive director of Rights Probe, which is a project of the Energy Probe Research Foundation. And one of the things I've been doing recently is looking at the mess that is becoming the land situation in British Columbia, and not just in BC, although it's most acute in BC. And people have been talking about the Cowichan decision in Richmond. Even more recently, there's the decision out of the Court of Appeal just last week about a piece of BC legislation that is also adding to the trouble. And so there's a lot of context here. It's a bit of a history. So perhaps I'll just go through a little bit of that to give some context.
Yeah, I would really appreciate that.
Okay, so let's go back to even before the Charter of Rights was enacted. There was an early draft put together by Pierre Trudeau. And that early draft of what eventually became the Charter of Rights included property right. The Charter of Rights suggested that you were going to have a right to property, as they do in the U.S. Constitution. By the time the document was in final form in 1982, that property right had been removed at the behest of some of the premiers. In the meantime, that initial draft of Trudeau's did not include Aboriginal rights. And before the final draft was embraced, there was a campaign, sort of a last-minute campaign, to put Aboriginal rights in there, and that was successful. And so we have now Section 35, which guarantees Aboriginal rights. It's actually not in the Charter, which makes it actually stronger than it would be if it was in the Charter. Okay, so we now have a constitution that has no property rights except for Aboriginal rights, including Aboriginal title. All right, so that Section 35 was worded so as to essentially affirm Aboriginal rights as they existed in 1982 at the time of the document. What's happened since then is that the Supreme Court of Canada has enlarged and reimagined Aboriginal rights, including Aboriginal titles, so that the thing has evolved and expanded since that time. Okay, so that's one thing. We come to the Cowichan decision, but before we get even to the Cowichan decision, let's talk UNDRIP just for a minute. UNDRIP
I just learned about this, and I've heard that you're the best person to talk to about it, so I'm excited.
This is an extraordinary thing. It sort of happens piece by piece by piece by piece, and you end up in a place that you never thought you would be. So the UN Declaration on the Rights of Indigenous People is a General Assembly resolution. That means it's not a treaty. It's not a binding document. It has no force of law. You couldn't go to a court in Canada and say, look, we have a UN declaration that says this, please enforce it. That can't happen. It's an aspirational document. At the time, when it first came out, Stephen Harper was in power, and the Canadian government said no to signing on to the resolution. That changed in 2015. When the Trudeau government came into power, they reversed their objection. Now, what does the declaration say? Well, it says all kinds of stuff. It has pages and pages of rights and entitlements that belong to Aboriginal groups. One of those sections, and I can just read it out to you. An extraordinary document. This is Article 26. Article 26 of UNDRIP says Indigenous peoples have the right to the lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or acquired. Right now, that statement is not conditioned on anything. It's not qualified. It says Indigenous peoples have the right to all to lands and resources. Period. Now, on its own, that doesn't mean anything in the law because it's a UN General Assembly resolution. It's not enforceable. So far so good, right? So it's an aspirational document. It's not really intended to be enforced, except the BC legislature comes along in 2019 and passes a statute called the Declaration on the Rights of Indigenous Peoples Act, which says that the government must make the laws of British Columbia consistent with UNDRIP. In other words, they are now incorporating incorporating the UNDRIP into British Columbia law. And this Court of Appeal decision that I referred to earlier says just that. It says, no, you passed a statute. That statute has the effect of incorporating UNDRIP into British Columbia law. Okay? So now we have a situation where the law in British Columbia basically says Indigenous peoples have the right to the lands and resources that they have ever occupied, used, or acquired. So that brings us to number one, Cowichan,
Yeah.
and number two, the things that the BC government has been doing. That brings us basically up to the present day. I'll just pause there and see if you want me to direct me in any particular direction.
Yeah, I guess to maybe just unpack it a little bit. So you mentioned that the problem is more acute in BC. Is it because like the way that that's always been described to me is that BC is mostly unceded land compared to Ontario? Is that a combination of that factor and the fact that they just made this political decision that you just mentioned that makes it so much more pronounced there?
That is correct. It's a combination of the fact that BC is largely without treaties, but without historical treaties for sure. And unlike Alberta, unlike Ontario, and so on, 95% of BC is Crown land, and that Crown land is largely unceded. And then you have, on top of that, you have the adoption of UNDRIP into provincial law. Now, the federal parliament has also done that. That federal statute applies to areas of federal jurisdiction, but so far, BC is the only province that has incorporated UNDRIP into its law in this way. So BC is subject to a double whammy. That doesn't mean that the other provinces are necessarily free from all this trouble. Because, for example, if there is a claim made for Aboriginal title in an area of another province, or for that matter, if there is a claim pursuant to a statute that says, for example, the statute hasn't been honored, the treaty hasn't been honored, or the treaty didn't mean that, or we signed the treaty under duress. I mean, there's all kinds of situations in
Yeah.
which the treaty is not necessarily the final word, but the potential for trouble is a whole lot bigger in BC than maybe anywhere else.
Right. So then, like, because in the province of Ontario, then with the renaming of Sauble Beach to the Saugeen Beach, and there's some land that was given back, I think, in that context, and then now there's this new thing that's supposed to be back up in court in 2026 with the Haldimand Tract. They're revisiting stuff. Like, how do ones like that come back to the table in that context? Is it a revisiting of the original treaty?
Well, so it depends what argument is being made. But just for a moment, let's go to Cowichan, because Cowichan has sort of set the table
Yeah.
for this. Cowichan is, people have been arguing about whether Cowichan is consistent or not with the law that existed before it. The path that the Supreme Court of Canada has laid down over time about what Aboriginal title means and how it can be established. And for my money, Cowichan is not an outlier. Like it's the first to sort of get where it's going, but it's not rogue. It's consistent with a path. So what Cowichan decision basically says, put simply, is that Aboriginal title and they're talking about Richmond here, but the proposition is a broad one. Aboriginal title is a senior and prior right to fee simple. So if you own a fee simple property on a piece of land that a court finds that Aboriginal title applies to, then the Aboriginal title is senior and prior to your interest. That doesn't mean your fee simple automatically disappears. But now there's a problem because whereas the day before the decision, you thought you had the biggest estate in property that was possible under our system. Now you are essentially underneath a senior and prior right. And what that actually means in practice, we're all going to find out over time.
So in that regard, then can we play that tape to the end a little bit? And I don't want to make you make any assumptions about motivations of the indigenous groups that are making these claims, but it's more to have it like, can we examine the incentives that might exist for them to do this? Obviously, like, land is one of the most pursued things in human history. And so there's that element. But, beyond that, in a modern economy, if they were to take possession of these sites and fee simple sort of still existed, but now they have the original tenure, I guess, I don't know what you would call it. Maybe you can use a more exact term, but functionally, is there a possibility that they could end up being like replacing the government that I'm owning this land from and paying tax to? Like, does that, what would that, let's fast forward to this being
Yes,
successful.
that's a very good question. It's a very good question. And one of the complications here is the nature of Aboriginal title. And this is something that the Supreme Court of Canada has been describing over time in cases. Aboriginal title is, so what we essentially have is two different systems of property ideas. The fee simple is the largest estate under our common law system of property that you can have. And but you still hold of the crown, meaning that the crown still has the underlying interest and they can basically do as they wish. If they, for example, if the government passed a statute, if the legislature passed a statute that said that they were taking your land, then they can take your land. Now, we happen to have in provinces across the country expropriation statutes, and those statutes say, here are the processes for expropriating a piece of property. If you're going to build a highway or an airport or as you like. And when you take the land, you compensate the property owner in this way. This is how you calculate the value, right? That's just a statute, though. So if they wanted to, they could legislate around the statute or decide that the statute needed to be changed, right? So your entitlement to fair market value compensation is dependent upon the statute. It's not constitutional, it's statutory. But we put all that aside. Fee simple means that you have all the property it's possible to have for a private citizen in the property. That means you have the right to exclude everybody else. And nobody else can have any rights in that property because you have the fee simple. Aboriginal title is a different kind of interest altogether. The Supreme Court of Canada has called it sui generis, meaning it's a different thing. It's its own thing. It's a thing not like the other things. And that's because it doesn't come from the same system that the fee simple interest is found within, right? So in theory, you would think it was not possible for a piece of property to be subject to fee simple and to Aboriginal title, because both of those interests give different parties the right to occupy and use and exclude from. So how can that be? How can you have two different parties with the right to exclude people from the same property? That doesn't make sense. And yet we are in a moment now where at this very moment on property in Richmond, there is both fee simple and Aboriginal title. So the court has said. We have to figure out what that means. One other piece of information. Supreme Court of Canada has said that Aboriginal title, where it is found to exist, can be surrendered, but it can only be surrendered to the Crown. In other words, the Aboriginal group that holds Aboriginal title can't just go into the market for properties and say, we have Aboriginal title, we'll sell you a fee simple. That's not how this works, according to the Supreme Court of Canada. You can surrender Aboriginal title, but only to the Crown. And when that happens, the Crown then has Crown land that it can parcel out and grant and fee simple if that's what it chooses to do. But that's how you transition from the one kind of interest to the other. But right now we have a situation where it looks like they simultaneously exist on the same place. And that That doesn't make sense. That's inconsistent. That's incoherent.
Yeah. So then I guess like I mean we are just basically trailblazing here. Like we don't. It's impossible to like to guess how this might end, but I think that there will be some sort of like this will sort of be a precedent setting result whenever it does we get to the end of it. Like what is the range of potential outcomes here?
Right. So I've seen, some Aboriginal leaders say something like, "Listen, we're not after your homes. We're not trying to kick you out of your house. Like, don't worry about this." And that may be true in some situations, but it's not really even a question of motivation. Here's the situation. The point is that for those fee simple interests that are subject to Aboriginal title. Now, the motivation of those groups is relevant to you. In other words, maybe they could if they decided that they wanted to. Before that decision, they couldn't do that because you have the fee simple, and that means only the crown through legislation and the processes in the act could you be separated from your title. Now there is somebody else with the authority or the apparent authority to be able to say to you, don't worry, we're not after your house. Your security of tenure is now based upon that answer to that question, which is a different kind of situation altogether.
Yeah, very complicated. If we can rewind to where, like, comparing this to an expropriation, where like the Crown can take land from individuals, and typically they're entitled to some sort of compensation, although maybe not. They're not no legal requirement, but they often are paid that. Like, what would happen? There's no comparable right in this case, right? Like, so would a citizen be encouraged to, I don't want to say like they would win, but like would they be encouraged to litigate the state for damages in that case if they suffer a financial loss? Or what would happen, assuming that it did result in somebody having their private property taken away?
Right. And in fact, a judge in New Brunswick last year in a similar case that hadn't gone to trial yet said that one of the possible outcomes in these kinds of cases where Aboriginal title is claimed and found to exist over land that is private, one of the things that a court might do is to order the government of the province in question to expropriate those fee simple lands, to hand them over, and then to compensate the fee simple owners for the value of the property. There are lots of possibilities here, and it's very hard to predict with any kind of certainty what the outcome's going to be. The combination of the courts and the Constitution, and to some extent DRIPA, which we can get into in a minute, because the BC government has been causing similar kinds of problems elsewhere on its own without the courts. This moment that we are now in is one where it's difficult to tell how this is going to be able to be fixed.
You mentioned similar problems elsewhere without the courts. What are you
Right.
referring to there?
All right. So in the meantime, we had the Cowichan decision, but in the meantime, the BC government has been over a period of time, this is, months and getting into years now, has been making agreements with specific Aboriginal groups over specific territory. For example, it has made an agreement over Haida Gwaii with the Haida Council. And this has nothing to do with the court. The BC government has done this on its own, along with the federal government, to recognize and affirm Aboriginal title over Haida Gwaii, the entire territory, in spite of the fact that there are private individuals with fee simple title over land on Haida Gwaii. And the agreement itself is incoherent because it says, on the one hand, we're going to recognize and affirm Aboriginal title. On the other hand, fee simple title will be honored. The Haida Council will have Aboriginal title over this property, but in the meantime, other levels of government will continue to exercise their jurisdiction. The provincial government will continue to build roads and finance hospitals and so on. It's like, if you look at this agreement and you think, okay, now who is in charge and who gets to set the rules and who has exclusive use over property? You'd be hard pressed to answer those questions. It's designed so that, and I don't know if this was an inevitable, accidental, or on purpose, but the thing doesn't make sense. You cannot answer those questions just by looking at the document.
It's such a mess. I have so many questions that I know a lot of them can't necessarily be answered logically at this moment in time. I might use this as an opportunity to pivot a little bit to something in my space, like in the real estate space, that is sort of like a layer on top of what you would call the stewardship or like ownership of land that that a state might have, which is there's different layers of what governments can do. So your municipal government can have zoning, there's provincial governments and even federal governments that can have different types of limitations and statutes and bylaws on top of land. Hypothetically, in these situations, and maybe that's a dangerous word to use when talking to a law professor, but if an indigenous group were to take possession of this land in the most absolute format that you're describing, could they not completely remove all of that, and not trying to create a bull case maybe for real estate investors who want to build whatever the heck they possibly could, but like, could they just basically say zoning doesn't exist anymore? There's no rules. Maybe there's no property taxes or land transfer taxes or development charges or all of those things. Like, hypothetically, is that an environment in which they could create?
Yes. So one outcome that I could imagine, if Aboriginal title has been declared to exist over a territory on which there is private fee simple title, since those interests are incompatible and the Aboriginal title is senior and prior, it would be theoretically possible that the Aboriginal group might say, Aboriginal title applies. We do not recognize or honor fee simple title. Please get off. Now, would that trigger either legally or politically the need for compensation for those people who had the fee simple title? You'd like to think the answer would be yes, but I don't know if that can be assured. Even on here's another complication though. Even on areas on which Aboriginal title exists, so that these areas of Aboriginal title are still inside the province and the country, and so the provincial and federal government still has their jurisdiction to certain extents to pass laws that apply generally to lands for certain purposes. Like, so for example, if you're a province and you're passing environmental legislation,
Like
the
the green
environmental
belt, maybe as an
legislation will
example, right?
apply to the land over which Aboriginal title is held. Right. So those legislated rules that are either in provincial statutes, for example, or even in municipal governments, if they happen to be in the territory where the title exists, if they have jurisdiction and if they can coexist with Aboriginal title to the extent that the courts have described the jurisdiction, well, the answer is they could apply. They could apply. It's not an absolute
Got it.
self-government kind of situation.
Okay. So my vision that the Haldeman Tract is going to be taken over and removed from the Greenbelt and developed into 100-story high rises from end to end and solve Canada's housing crisis instantly is not a likely outcome, I suppose, is I guess the logical conclusion there, which makes sense.
Yeah, well, I'd have to look at that in a bit more detail. I'd be interested in the case to be made where that would be possible, but I don't know.
I don't know. Like, it was kind of like that was sort of me trying to assume like the absolute most absurd devil's advocate outcome that I could create with this. And that was kind of like the
Well,
funny
so
version of
let's
it.
just observe this just for a moment. So the Supreme Court of Canada, on occasion, has described what the nature of Aboriginal title is. Now let's just observe this. Number one, it's a communal right. It's a group right, which is one of the problems, right? Because that means that the elites and the leaders control the land. That individual Aboriginal people don't own these simple tracts of land inside this area subject to Aboriginal title. It's a group right. And it does include the right to control the use and exclude people and so on. But on the other hand, because it's a group right held for the group, there's also restrictions on the nature of the uses that can be put to. For example, you can't use it in a way that would deny future generations members of that group the benefits of the land. Right. So Aboriginal title is, we can put it this way, subject to more kinds of restrictions on use than fee simple title would be.
And so in the case where like they're looking more for like, or if they're saying, hey, look, we don't want to take your property away, and they're maybe looking for like financial reparations or whatever it is, are they like, how would they quantify that? Is it like, hey, you've been collecting property tax and land transfer tax, and here's an approximation of all of the income that you've earned off of land that was ours. We want all of that money plus interest that you've earned since the treaty was signed. That is that like,
Sure.
yeah.
Well, I mean, so all the parties are going to frame this in the way that benefits them, right? So that's one way to frame it if you want to maximize the return. The reverse would be to say, well, no, actually, what you've been denied, if I can put it that way, is the title to this area of land, which was only developed because you didn't have title to it. So what you actually lost is title to, this many acres of undeveloped land in the middle of nowhere. Not the market value of the land as it is right now, because the
Right.
land right now is developed. It has infrastructure, it has buildings, it has, it's a urban area. That's not what it was that the group long ago, lost connection to. So there's very different ways to frame this. And in the end, I mean, sure, this could end up in a court trying to decide what the amount was, I suppose somehow, but it's more likely to be a political negotiation.
Hmm. Yeah, interesting. I would assume, I mean, if I'm a policymaker, I would want to settle this, not let it go through the courts, just because it sounds like a PR nightmare. It's already evolving into one, but I don't know. I mean, unless they're trying to create precedents, maybe.
Well, yeah. So talk about precedents. Here's just let me add one more piece of the story about Haida. So the BC government has been proceeding in the way that it has by agreement, with certain Aboriginal groups, like on Haida. This is all a manufactured problem in BC. Number one, it was because the BC legislature passed DRIPA to give the government the mandate to do this kind of thing. And number two, the actual entering into these agreements, which are not obligatory. This is the BC government acting on its own to create these problems. So in theory, if a new government came into power in BC, it could reverse those things. It could repeal DRIPA. It's just a statute, not part of the Constitution. And
Got it.
it could pass legislation nullifying the agreements. However, on Haida, what happened after the agreement was signed is that the Haida Council and the BC government and the federal government applied to the court for a consent order, a consent declaration saying that Haida title on Haida pursuant to the agreements was now a constitutionally protected right under Section 35 of the Constitution, meaning now you can't touch it. It's done. So even a future government elected in BC can't go back now to reverse that situation because the court has given its blessings that it now is contained within Section 35. So that's game over.
What a mess. I have one more question, I think, and then I'll sort of maybe ask you if there's anything that I've left out or that you feel is necessary to add here. But mine is, I mean, selfishly, I'm in a profession that is we trade we trade land, right? We trade property. I'm trying to get ahead of this because I have concerns that this is going to become. Yeah, I'm starting to hear in regards to the Cowichan stuff and in BC that lenders are getting a little bit careful about these properties. Title insurers are starting to draft things to protect themselves against, um, having to pay out on this type of stuff happening on fee simple property. Buyers are certainly not super motivated to be buying in areas where land is disputed for the time being. Do you think that there is something that my profession can do to be proactive or should be doing in the real estate space that we should be doing to be proactive about protecting buyers and sellers of land in these areas or anywhere in Canada? Because it seems like nowhere is sort of safe at the moment. Advice, maybe that's the wrong word again to use with a lawyer. We'll say it's not advice. Nothing on my channel is advice, but what kind of things could we do to protect our clients?
Right. Well, and thank you. This is not advice, so go see a
Yeah.
lawyer. But if I was talking to a real estate agent, I would say that the first thing that they ought to do is to avoid giving advice. Like don't suggest to your client, whether buyer or seller, that the situation is a certain way with respect to Aboriginal title. It's just a dangerous thing to do because you don't really know. And to suggest that before any client signs an offer, that they talk to a lawyer. Not that the lawyer will necessarily have firm answers on any of these things either, certainly at the present time, but you'll at least have the sort of the latest word from a real estate lawyer about, what he or she thinks the situation is and how secure or unsecure the title is that the person might be acquiring. But let's observe this. So people have been wondering why it is that this problem isn't reflected when they go to see their title on the land titles system in BC. Like you have the Land Titles Act, and that is supposed to work by guaranteeing the security of the title. It's on the register, and yet Aboriginal title comes along and suddenly, the register still looks the same, but now the security of tenure has been undermined. And so how can that be? And the answer is that land title system acts within the one system I was talking about. Your fee simple title is still good within that system. Like there's nobody else acting within that system who could say, well, you don't have fee simple anymore. You do still have fee simple. It's just that this other thing, the sui generis from the other category, is now coexisting, and that's the thing we don't really know how it's gonna pan out. So the indication of what you read, the indication from what you read on the land title register is not going to reflect the problems that we've been talking about. One other thing, and this relates to the BC government. The BC government has been talking, and this is my opinion, has been talking out both sides of its mouth on this. Right?
Yeah.
You will have heard perhaps the Attorney General after the Cowichan decision say, you know, fee simple title shouldn't be, subordinate to Aboriginal title. We'll do our best to yada yada yada. The BC government has been causing a lot of these problems. It's the BC government that voluntarily made the agreement on Haida. The BC government has been making other agreements with other groups to give management rights and so on to these groups. And so it seems to be part of the BC government's agenda to enlarge Aboriginal rights and Aboriginal title at the expense, potentially, of other private BC residents who hold other kinds of property interests in the same land. So, I don't buy these political statements that suggest that the BC government is on this and they're going to try and fix it. The BC government has been one of the authors of this problem. And so I would not rely on those assurances to become confident that it's going to go away.
Yeah. Yeah, I would say it appears to me that it's doing the exact opposite of going away. I think this is very much just getting started by the looks of it.
I agree. Yes.
Yeah. And I think it's interesting that, I don't know if it's just because of Cowichan and that, there's a kind of light getting shined on the stuff happening in Ontario with like Saugeen and the Haldimand Tract, but it seems a little bit less complicated in Ontario compared to BC, obviously. But it seems like there's no place in Canada that's necessarily immune to this, and so I'm interested to see how things progress there. Is there anything that you feel like I left out of this discussion, or a question that you wish that I asked you before we wrap up here?
And not off the top of my head, no. So there are going to be lots and lots of details in particular situations that arise that who knows what they're going to be. But I think that's the big picture.
Okay. I'm gonna put your website and everything in the episode description and in the YouTube notes. But is there anywhere that you'd like for people to reach out to you if they have questions about this? Do you want to field questions about this? I can also tell people to completely leave you alone.
Thank you. Yeah, right. I appreciate that. So I'm not in a position to answer, legal questions where they're seeking
Yeah.
advice on their own situation. You really need to talk to a real estate lawyer for that. And every
Yeah.
situation is going to be, there's going to be obviously commonalities, but there's also going to be particularities that you need a real estate lawyer to look at. If they want to check out what we do at RightsProbe, we have a website where all our work is featured, rightsprobe.org. If they want to follow me on X, I'm at Pardy Bruce. I also have a Substack, Bruce Pardy at .substack.com. Otherwise, they're welcome to contact me about big picture things. But thank you very much for asking the question.
Yeah, my pleasure. And thank you so much for your time. I really appreciate it. I learned a lot from this discussion. I look forward to having continued discussions about this as we get more news out of the Cowichan stuff. And if this Haldimand Tract in Ontario actually does end up going to court in 2026 and doesn't get settled prior, I'm interested to see, and I'd love to get your take on it. I did a video about the Haldimand Tract, and I must have had 100 people in my comments say that I had to talk to you about this stuff. So I'm glad I did, because it made me a lot more relaxed about the situation, to be honest with you. I think it's very easy to get doomeristic about stuff like this, and I think people really tend to, because a lot of people are looking for bad news in Canada because things don't feel good here.
There's a lot of bad news to go around in all kinds of areas, for sure.
Yeah, for sure, for sure. Well, thanks again, and I look forward to chatting further about this in the future, and I really appreciate your time. It means a lot to me.
My pleasure, Daniel. Thanks for having me.
Yeah, take care.